Good day, ladies and gentlemen. Joy Stephen from the Pollensis Studios. Here is the case law, Singh versus Canada. Case law is not meant for people interested to apply for immigration to Canada, but may be used by those who feel the system is not fair, to gain an understanding of the recourse available in Canada for a negative decision. Content for this video is sourced from information distributed by Thomson Reuters. Judgment in this case is attached in my blog reportersreport.com as a PDF document. This case is all about immigration, visitors, general. Applicant applied for Saskatchewan Immigrant Nominee Program SINP under farmer entrepreneur category. SINP invited applicant to visit Saskatchewan. Applicant sought temporary resident visa. Officer noted applicant did not disclose the applicant was previously asked to leave the United States 19 years ago. Applicant was provided 30 days to respond to officer's concerns. Applicant asked officer to consider that removal was result of his overstaying his time in United States following a failed refugee claim and not due to criminal or medical inadmissibility. Applicant also said that he had declared such removal. If he had declared this removal, the previous removal from the US, it could have resulted in refusal of his admittance in Canada. Applicant's application for temporary resident visa was refused. Applicant sought judicial review. Application was refused. There was misrepresentation. It was not for applicant to decide what was relevant. Applicants were required to make full disclosure. It was for officer to decide what was relevant and what weight to give any particular fact disclosed. It was not whether visa would have been refused had full disclosure been made, but rather point was that it could have inducted or induced error because it could have impacted officer's decision on whether to provide the permanent resident, whether the applicant would leave at the end of the visa period and deny the visa. And it could have also induced error if there was other inadmissibilities. Applicant's failure to understand clear wording could not be used to avoid consequences of misrepresentation. Given clear questions and instructions on form, it was not reasonable for applicant to believe that he was not misrepresenting material fact when he decided to omit information in which he was fully aware. Misrepresentation was clearly material to decision that had to be made. Reasons were adequate. GCMS notes were part of reasons, and notes clearly explained why non-disclosure was found to be a material misrepresentation. Very interesting case, Singh versus Canada, March 25th of 2015 from the federal court. Thank you.